Hi, my name is Natalia Willette, and I am a real estate attorney here in the state of Florida. I've been practicing law for a little over 10 years and mostly in the real estate transaction world. So today I wanted to talk to you about tax deeds, and specifically tax deeds in the sense of what are they? What is a tax deed? How can I make a tax deed marketable for my clients? And what if a tax deed needs to be undone? So those are the topics that I'm covering in today's seminar, and that is what I want you to focus on. I'll give you a little bit more background about me right now. I practiced for about 10 years as in-house counsel for a title company in the state of Florida. So I've seen a lot of transactions regarding interesting types of deeds, from certificates of title regarding foreclosure to tax deeds to sheriff's levy deeds, because the practice that I was in, the title company that I worked for, focused specifically on real estate investors. So that is my background coming into this. For 7 of those years, I was also the president of said title company, so I can tell you that I've also related in the sense of the claims aspect of it. What is the challenge, the risk of bringing in these types of instruments and insuring these instruments so that we can issue a warranty deed or a special warranty deed for end buyers in these transactions. I've also litigated hundreds and hundreds of tax deed quiet title cases. So I'm very, very familiar with tax deeds and how they work and the challenges that come up in dealing with these tax deed transactions. And then recently I wrote this book. It's about tax deeds, how to become and stay wealthy by mastering liens, possessions, and marketability. And today we are going to be focusing mostly on marketability and challenges to that in the terms of litigation. So not so much from the perspective of a real estate investor, but from the perspective of a real estate attorney that represents a real estate investor. So the first part of my course is tailored to introduce you to what a tax deed is and what it is not. The second part is going to discuss specifically tax deeds versus warranty deeds and other types of instruments that are used to convey title here in the state of Florida. The third part is going to be the bigger chunk of my discussion. It is going to talk about challenges to quieting title. So if you are hired by an investor or property owner to clear up their title issues for purposes of a tax deed, I want you to know what some of those challenges are, the most common challenges, some stranger challenges that come up, so that you're prepared for your client. And then lastly, I'm going to highlight the differences that might come up when your client's tax deed is being challenged, or if you represent a party who is trying to challenge a tax deed. And all of this is governed largely by Chapter 197 of the Florida statutes. So let's begin with Part 1. A tax deed. What is a tax deed? So if you look at the history of transfers of title, right? Real property law is one of the oldest sections or areas of the law that we deal with as a common law nation. And for the most part, real property matters are matters of the common law. That is to say, cases have built up over centuries in some cases regarding real estate. And that kind of defines the rights and obligations of property owners, tenants, etc. But a tax deed is not part of the common law. A tax deed is a pure creation of the Florida legislature. And a lot of other states also have tax deed statutes that kind of create that ability of the state to make this particular type of instrument. So that's the number one thing I want you to take out of this section, is that tax deeds are not instruments based on the common law. So you are going to have to heavily rely on the statutory definition, the statutory background in 197 of the Florida statutes to understand what is your clients' right and respective obligations and respective limitations when they have acquired property via a tax deed. So how does a tax deed arise? What makes a tax deed possible? Well, if there's a common adage here in the United States where there are two things you can't escape. You can't escape death, and you can't escape taxes. So as far as taxes go, the state of Florida does not have a state income tax unless you are a Florida corporation. But if you're an individual, if you're an LLC, you are not subject to income taxation. So how do we raise revenue in Florida? Well, in Florida, we raise revenue through generally two means. The sales tax, which is imposed at a local level, and then, it depends. So, for example, in Hillsborough County, you can have an 8.5% sales tax. In Pasco County, it's 7% sales tax. So that sales tax is a way of raising revenue for the state. And then the other main way of raising revenue for the state is, of course, property taxes. And property taxes are dependent upon property assessments. And there are certain exceptions to taxation, but for the most part, your property, if you're a property owner in the state of Florida, will be subject to assessment and taxation. So the property appraiser goes out to a particular property, takes a look at it, assesses it, determines what neighborhood it's in, the area, who the owner is, how they own it. Do they own it as homestead property, meaning is it the primary residence of the individuals living there? Are they veterans? Are they elderly? That kind of ownership assessment is made. And then from there, they make a determination as to what is the value of the property. And they take that value and that determination of the ownership rights and the characteristic of that particular owner, and they send those assessments over to the tax collector's office. And the tax collector's office job is, of course, to collect the taxes, to send out those tax bills, those notices to the public to let them know that taxes are owed. Now, taxes are owed by March 31st of the subsequent year of the assessment. So in the state of Florida, that means that our taxes are paid in arrears. They're not paid in advance. So if I'm going to pay my 2020 property taxes, I am not going to pay my property taxes right now. I don't even know what my property taxes are. The tax collector's office doesn't know what my property taxes are. The tax bill actually comes out November 1st of this year for 2020 property taxes. And then you have all the way through March 31st of the next year of 2021 to pay those property taxes. Property taxes become delinquent as of April 1st of that subsequent tax year. So when people have had an assessment of property taxes, the tax bills get sent out, and people don't pay those property taxes, well, then you've got a tax delinquency. And a tax delinquency is what opens that door for the process to get to a tax deed to be formulated. So a tax delinquency will lead to tax certificates. Tax certificates are not tax deeds. Tax certificates are a prerequisite to a tax deed or a step prior to. So if there are delinquent property taxes, well, the state still has to figure out a way to raise revenue. And how does it raise this revenue if people aren't paying their property taxes? The Florida statutes under Chapter 197 have created the ability, the process for the tax collector to raise that revenue of those delinquent property taxes by offering the public a chance to bid to pay those taxes. And so you're thinking, why would somebody else want to pay my own property taxes? And the reason why is because they are allowed to get interest from having paid somebody else's property taxes. So what happens is the tax collector's office is allowed to have a public auction, an auction of, think of it as a bond. Your tax delinquency becomes a bond, and the state government pays interest to the highest bidder, or lowest bidder really in this case, for payment of your property taxes, of your delinquent tax liability. So tax certificate auction takes place. The minimum you are going to get as a rate of return on these tax certificates if you go bid is 3%. And bid auction will start at 18%. So if you are familiar with the interest rates set as the highest level here in the state of Florida, that's 18%. And they start those auction bids at 18%, meaning you're a member of the public, you want to pay John Smith's property taxes, the bids will start at 18% all the way down to 3. And then the lowest bidder, meaning the investor who is willing to pay the lowest or get the lowest rate of return on their tax certificate, will be the winner of that tax certificate. And that way the county gets the income from those delinquent property taxes, and they only have to pay a certain interest rate of return annually in exchange for somebody else having paid those taxes. So it's worthwhile to the government because it's much better to have to pay only lose a percentage of those taxes versus lose the whole tax amount for the year for however many properties are delinquent. Minimum bids on these are based, of course, on the tax delinquency and the cost of publishing notices for tax certificate auctions. So if you're a winner in this auction, you're going to get a tax certificate, and a tax certificate is a prerequisite to getting a tax deed. Once you are a tax certificate holder, you can either keep it and gain your annual interest rate of return. It's much better than investing your money in a bank, probably much better than certificates of deposit in this day and age. But if you want to be able to acquire that property, let's say you started bidding for those tax certificates because you're interested in the property. You like it, you want to be able to buy the property. And so if you have held on to a tax certificate for at least 2 years, then you can petition the tax collector to start the process to get a tax deed auction on the books. And in order to get a tax deed process going, you as the tax certificate holder have to do the following things. So this is what your client would have to do. Your client would have to go and petition for the tax deed sale. Your client would have to redeem all of the outstanding tax certificates. So not just yours, but you're going to redeem every other tax certificate holder for that property because they're going to get satisfied through the sale, or that is the idea. That information gets taken to the clerk of court along with your information sheet that you've submitted requesting the tax deed sale, the tax deed application. And the tax collector's office is going to order a title search. This title search is tailored to meet the statutory notice requirements that the tax collector and property appraiser and clerk of court have a duty to notify certain parties that there's going to be a tax deed auction for that particular piece of property. This report and the bag of information gets sent over to the clerk of court of the particular county in which the property is situated. The clerk of court is then going to prep and send out all the notices of the tax deed sale. They're going to set a sale date. They're going to contact a local publisher newspaper, and they're going to publish the sale for 2 consecutive publications. And from there, the tax deed sale date will come up. So if you're a tax certificate holder, you've done the redemptions, etc., you are free to bid at that tax deed auction. Everyone else that is a member of the public that has the cash ready to go can also bid at this tax deed auction. And so the tax deed auction takes place, and this one is more like a traditional auction. It's not about the lowest willing party. It's about whoever bids the highest during the time period provided for the sale. So once you are the highest bidder, your client, the investor is the highest bidder, then at that point they will get a tax deed. And a tax deed, of course, is a type of title to the property. So tax deed versus alternatives. I want to talk to you about or remind you about what other types of deed are, the kind of weight that they carry so that you can distinguish them from a tax deed. So this is part 2 of what you should know about tax deeds versus other deeds, and then we're going to get to marketability and what you have to do as an attorney to make that title marketable for your client. So tax deeds and alternatives. What is marketable title? Marketable title is title that is, for all intents, clean. It has the weight of true ownership to convey out, and it has a clean slate so that the purchaser isn't going to get stuck with whatever encumbrances, liabilities are attaching from the past in the history, in the chain of title of that particular piece of property. So that is what marketable title is. Marketable title is not clouded, meaning there aren't doubts as to ownership, liability, encumbrances, alternative claimants. That is marketable title. So I want to talk to you about like the premium title that is defined as the epitome of marketable title, and this is title that you can transfer via a warranty deed. And warranty deeds have 4 covenants. Those are 4 promises, warranties, guarantees that come with this type of title, and this is the desirable title for your client and for end buyers. And they ultimately want to be able to convey title that is marketable. So if you have a title to property that you can convey via warranty deed, then you are guaranteeing the following for your buyers, or your client is guaranteeing the following for his end buyers. 1, it's the covenant of season. So what does season mean? It means you are seized in the property. You have the actual right to possess the property. You have the actual right of ownership to the property, and it's a legal right. You don't have an equitable right to property. You have the actual legal right to the property, and you have the right to convey that property, meaning if you are entitled, you are not prohibited from conveying that title out to anybody else. So that's the first covenant, covenant of season. The second covenant in a warranty deed is the covenant against encumbrances. So what you are saying here is that the property is being conveyed with that clean slate. It's not going to have a continued mortgage obligation. It's not going to have certified final judgments that are attaching. It's not going to have county liens, governmental liens, things like that attaching. It is going to be free and clear. That's not to say that when your buyer purchases it, they're not going to put an encumbrance right then and there, because for the most part, when people buy property, they buy it with some financial assistance, and so it gets mortgaged very quickly thereafter. But when you are conveying it, what your client is conveying is a free and clear, no encumbrance property. The next warranty of title that we're going to discuss is the covenant of quiet enjoyment. And what does quiet enjoyment mean? It does not mean that you are going to have property where your neighbors are going to be silent and you're never going to have to deal with their house parties, or you're never going to have to deal with like noisy commutes or anything like that. It has nothing to do with volume and sound. What it means by quiet enjoyment is that the grantor is guaranteeing to you that you're not going to have a random third party show up and say, I have superior title to you. And this has to do a lot with clouds, meaning the person who is transferring title to you, along the chain of how they got titled, there wasn't anything there that created like a doubt or like a branch or issues in that regard. And this is what quiet enjoyment means. It means your client is not going to get hounded by a random stranger showing up and saying, I have superior title to your property. And then finally, we have the covenant of further assurances. So this is kind of like the only warranty or promise that relates to future aspects. Everything else, every other covenant, season, quiet enjoyment against encumbrances is relating to the past history of that property. But this particular one is relating to future aspects. And so what the seller is telling you here in terms of granting a warranty deed is that they will take the action necessary to defend your title as the end buyer, taking care of documents necessary to clean up title, litigating to clean up title, paying off claims that may have just been missed through a search of the official records. This is that covenant of further assurance. And this is what makes warranty deeds so valuable. And this is why people do not or should not do real estate closings in which they transfer title via warranty deed or special warranty deed without going through a title company and getting a title insurance policy in place. Because as a seller, do you have the endless funds to defend against those types of claims? Or do you want to pay for an insurance policy for your owner that'll take care of defending against those claims and shift the burden of searching and ensuring that every prior encumbrance, possible third-party claim, etc., gets taken care of through the premium and the policy? You almost always want to make sure that there's something like that in place. The difference between a warranty deed and a special warranty deed is that a warranty deed, the grantor is warranting that further assurances, that defense against other claims, going back to the chain of title before their ownership. Whereas a special warranty deed limits that further assurance defense to things that arise under their name in the chain of title. So like a mismortgage that was under my name as the grantor, things that I have to fix because I received title and it was weird or irregular, or there was an issue in the legal description, but they're limited to that grantor, and that's what makes it a special warranty deed. That's the limit there. Of course, you will see also on the official records in your practice quitclaim deeds. And so what is a quitclaim deed? A quitclaim deed isn't guaranteeing any of those warranties. A quitclaim deed simply says, if I have any interest whatsoever in this particular parcel of land, any interest whatsoever, then I'm giving you my interest. But one of the things about warranty deeds is that if that person who is giving your client title, or if your client is given this type of title and they don't actually have legal title, they don't have the right to possession, if nothing is clear about their interest, then that title is meaningless. So quitclaim deeds really are only as valuable as the type of title and ownership interest underlying the grantor. If the grantor had title via warranty deed and is now quitclaiming it over to, let's say, himself and his spouse, that's still good title. It's marketable title to this degree that that person was legally the owner and capable of having all of those rights and capable of conveying full ownership rights, fee simple title. But if you are the heir, for example, of the legal owner of record, but there are other heirs, if you're conveying title via quitclaim deed, you're conveying what may or might not be any interest at all in the property, depending on whether the prior owner had a last will and testament, whether they had other children, so it depends. But you shouldn't rely on a quitclaim deed to think, oh yeah, this is marketable title if you're looking through the chain of title. So that's a difference there. Tax deeds. So what is a tax deed? A tax deed is what's called paramount title. It's different. Warranty deeds, quitclaim deeds, all of those are dependent upon the chain, the history of ownership in the parcel going back in time, back to when the original paramount titles were granted by the state of Florida to property owners. In different parts of the country, some of those original paramount titles were like the land grants from the viceroyalty of Virginia to such and such person, and that's how the chain of title came down. With the state of Florida, you have similar things, dating back to about the 1840s when those land grants were given out, moved forward along the chain. But a tax deed is paramount title as well, meaning it is seen as brand spanking new title from the state. But that does not equal that it is marketable title. And the reason why is because a tax deed is still a creature of statute, and it is dependent upon the clerk and the tax collector and all of those parties involved in having a tax deed sale actually having followed through on all the steps required, and on that sale not having violated constitutional requirements, on that sale having conveyed an appropriate legal description, and those kinds of things. So that is why paramount title does not equal marketable title. And if you talk to any worthwhile title insurance underwriter, the companies that issue title insurance policies, here's what they're going to tell you. Oh, your client has property that they acquired via a tax deed? Okay, how long have they held it? Less than 4 years? Okay, we're going to want a quiet title in order to insure that property. So, it is not marketable title. It is brand new title, but some liens survive. And it is brand new title, but it could be undone. So those are the things you have to keep in mind, and you have to explain to your clients when they come to you saying, I have a tax deed. I heard this is like perfect brand new title from the state. You have to slow them down and explain paramount title versus marketable title. So in regards to tax deeds, like I've mentioned, you need to make sure that the clerk, tax collector, all those parties did what they were supposed to do under the Florida statutes that allow for the creation of tax deeds. You have to make sure that the legal description that they've conveyed is an actual effective legal description, that that parcel closes, that it doesn't overlap with another neighboring parcel, those kinds of things. You've had to make sure that like due process has been met. So even though complying with the statute, everything was checked, they may have still violated due process requirements and having a sale. And the property may have been improperly assessed. It may have not been subject to taxes or to that tax level. This is why underwriters demand quiet title suits, because that is how you put proper parties on notice and really verify to make sure that the clerk did what they were supposed to do, the tax collector did what they were supposed to do, that you've got good title to land for your client, and that they can then market it, sell it, and convey it via a warranty deed that gives all 4 of those guarantees to the end buyer. So now let's talk about quieting title. This is part 3. Quieting title being a prerequisite to marketability, and I'm going to take a good amount of time discussing quiet title cases. I'm going to bring up some challenges. I'm also going to give you an idea of liens that should be included, liens that should not be included, the differences between what the clerk is obliged to give notice on and not, so that you are not committing the mistake that I see so many practitioners do, in that they put in the wrong defendants, unnecessary defendants, in their quiet title suits. So let's begin. When you are a tax deed owner and you go to a title company and they tell you you need to do an action to quiet title, you need to find yourself a real estate attorney that is capable and understands what it means to quiet title. Quieting title simply means you are removing those clouds to marketability for the purpose of having insurable and marketable title. Because tax deeds are based on a statute, they're creatures of statute, you really do have to rely on statutory language. Now, the great thing about tax deeds is that under 197552 of the Florida statutes, they are, the fact that a tax deed was issued, just that it was issued, is prima facie evidence of the regularity of all of the proceedings from the valuation of the lands to the issuance of the tax deed inclusive. So what does that mean? It means that the burden is not on you as the tax deed owner to show that the clerk and tax collector and everybody complied and notice and the legal description is good, etc. The burden's not on you. The burden is on those parties that had an interest prior to the tax deed being issued, the ones that were responsible for the delinquency, etc. The burden is on them to show that the tax deed is not superior paramount title. So generally that means that for you, drafting a complaint is going to be very much reliant upon the language of that statute, 197552, about this, prima facie, everything was done correctly. These are the people that have a prior interest. It is up to them to raise a defense against this tax deed and to overcome that burden that the statute says. But again, prima facie doesn't equal slam dunk. Oh yeah, I just have to name these parties and I'm going to be perfectly okay and it's going to be great for my client. No. So what I recommend before you even decide to take on a quiet title suit or to file suit on behalf of your client is you go down to the tax deed department of the clerk of court and you go look through that tax deed file. Go look through the tax deed file. Do your own title search, but you need to see, who did the clerk notice? Who got sent notices of this tax deed sale? Does that match up with your chain of title as to who the prior owners are, who the prior lien holders are? That is very, very important. You need to see these certified mailings because the clerk of court is required to send out notice via certified mail to parties prior to having a tax deed sale. The parties that are required in the statute, which I'll discuss in a moment. So you need to see, did the clerk actually go through and send out all those things via certified mail? What addresses did they use via certified mail to get to the parties? Did anything come back unclaimed? Did anything come back undeliverable? These are all things that are going to put you on notice as to issues that might arise and that you might want to nip in the bud in your complaint. So practice advice there. The circuit court has original jurisdiction over an action to quiet title based on a tax deed. You are not going to be filing these in county court. I have seen the mistake made where people file in county court because they think, well, the tax deed was only issued for $8,000. That doesn't meet the jurisdictional monetary amount things to get it to circuit court. That's irrelevant. The circuit court actually has original jurisdiction in these transactions, so please don't make the mistake of putting it in the wrong venue for your client. And then naming of the proper parties. So this is something that really needs to be taken to heart when it comes to real estate attorneys and doing these cases for your clients and defending these cases for your clients. Chapter 197.552 of the Florida statutes. So the same one that says, prima facie evidence. That one has carved out an exception to say specifically the types of interest holders in the prior chain that do not get wiped out via tax deed. Or to put it another way, that are still superior interest holders to the tax deed. And those are the governmental, so the municipal and city liens. Why do they get superiority? Well, we can think of it this way. The purpose of a tax deed is to encourage the collection of tax revenue, to encourage new property owners that will pay the taxes and understand the tax liability. But as part of that, if a property has been sitting vacant for a while, it's becoming a burden with overgrowth and trash and etc. Well, the county or the city, if it's located in a smaller municipality, they're going to have to clean up the house, maybe demolish it, mow, all of that, and make sure that house, that property or vacant land is not a burden to the remainder of the neighborhood, because that's also going to depress property values and therefore depress the taxes that you can collect on those pieces of land. And so the Florida legislature said, okay, we will make this paramount title as to everything except for municipal and county liens. So municipal and county liens survive. So when you go look at the tax deed clerk's statement to see who's been given notice of this tax deed sale, well, all interested lien holders of record are supposed to get these notices. So if you're, the mortgage holder, Bank of America, you're going to get notice. If you're the prior owner, you're going to get notice. If you are a certified final judgment lien holder, you're going to get notice. If you are, the Internal Revenue Service, and you've got a lien, on like an IRS lien on that prior owner, you're going to get notice. If you've got a county lien for demolition, you're going to get notice. All those people are going to appear on the notice. But the fact that they are on the clerk's statement of notice does not mean that they get to be put on your action to quiet title, because your action to quiet title should be focused on those parties that have an inferior interest to your tax deed, not a superior interest to your tax deed. You can't quiet out, meaning you can't claim superior ownership rights and interest to a tax deed property against a municipal or county lien that is protected by the very statute that created a tax deed. And I have seen so many times where attorneys improperly name the county lien holder, the city lien holder as a defendant in an action to quiet suit based on a tax deed. So don't do that. Please don't waste your client's money serving them. You're just creating worse litigation for them. So don't. Parties that you should name in an action to quiet suit, to quiet title. That IRS lien, you can. You can name them as a defendant in the suit. Now you're thinking, oh man, but an IRS lien, that's a tax lien from the federal government. Isn't that superior? Isn't there, when it comes to supremacy, shouldn't the internal revenue lien have more priority than the tax lien of a state? Well, Generally, the answer would be yes, except for that the federal government has carved out an exception to where they can be named a party in a quiet title suit for their lien interests, so long as that foreclosure based on the taxes went through to a sale. And in this case, it went through to a sale because that's how your client acquired the title. It didn't go through a judicial sale process. It went through an administrative sale process, but it still went through to a sale, and therefore they have considered themselves to be inferior to that degree to a state tax lien. The reason why is because it is very important for the federal government that states can raise revenue. And so they've seen it as a willingness to, concede on that ground, because they don't want to have to keep giving the states more money for projects, etc. They'd rather the states be able to raise revenue, and that's why they've allowed themselves to become parties. But there are special priorities, considerations when it comes to naming somebody like the Internal Revenue Service as a party. The IRS has a 120-day right of redemption. So what does this mean? Well, if a tax deed was issued May 1st, you have to count 120 days from there. And during that 120-day period, your client shouldn't be doing too much with the property until they get a release from the IRS or a disclaimer of interest pertaining to that property. I like to encourage including them in a quiet title suit, getting the Internal Revenue served. 99 times out of 100, that Internal Revenue Service is going to very quickly file a disclaimer of interest to the property and just move along the way, and then you're fine. You don't have to deal. You don't have to wait until the 120 days expire. It's just there. It's gone. It's an interest disposed of for your client, and it's done very nicely through the quiet title suit. There's also a certificate, a document that you can fill out the application for, send it over to the IRS, and see if they'll provide a release to record in the official records. But I personally find that it might take the IRS longer to do it that way than if you just serve them when you file suit for quieting title. So when you are naming parties that are entities belonging to the U.S. government, you must make sure that in your complaint you are stating the statutory authority that permits you to sue an agency of the federal government. You've got to do this because they can move to dismiss your case if you do not state the grounds in your complaint clearly as to why you can name them a party. So make sure that you are naming the proper statutes. They're all in my book, to give you that priority clearly as to why you can name them in the suit, and you don't want to have to deal with a dismissal, and you don't want to look terrible in front of your client by having forgotten those basic prerequisites that we don't think about when we're like, oh yeah, it's a tax deed, it's superior title, the IRS is not a party that's excused from this in the statute, so I'll be fine. No. So your search for purposes of who you are going to include in an action to quieting the title of the tax deed is going to look different from the tax collector search. The tax collector is interested in the parties that are named in the statute that require notice. So the owner of record, the lien holders of record, like mortgages, etc. It could be a homeowners association lien as well. The county, any county liens, any city liens, those parties are going to be the ones that the tax collector cares about sending notice to for purposes of the tax deed sale. What you need to care about is a much more thorough search going back, but you're actually not going to be concerned with that lien from the county for cleanup and trash, etc. You're not going to care about those county liens and city liens, not because they're not important to your client. Absolutely, let your client know what those liens are, what the liabilities might be, because they do have to pay them. But for purposes of naming defendants in your suit, they're not so relevant. You're going to want to make sure that you have the prior owner, but you look at the deed in which they acquired title. So if the prior owner acquired title via a quitclaim deed, you should go back to their grantor. How did the grantor acquire title? Did that grantor also acquire title via quitclaim deed? Okay, well then you also need to go back. Go back until you have warranty deed, and then do a search even further back just to make sure that this warranty deed recipient actually got it from somebody in the chain that had title, and then from somebody in the chain that had title. You should go back because you want to make sure that clouds are actually being addressed. So this is the opportunity to really do that clean lineup for your clients.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Open. O-P-E-N. Open.
Now, if the prior owner received a warranty deed and it was through a title company, you know that there's a title insurance policy in place that can be relied on. And at that point, that's the party that you name as a prior owner. Same thing. You're going to name, Bank of America, Wells Fargo, whoever owns the mortgage. You're going to name the homeowners association as a defendant in the suit. You're going to name those parties, what I call the private lien interest holders, as well as, like I said, the Internal Revenue Service, the Department of Justice. If there's like a RICO lien or something like that, you're going to name them in your quiet title suit. Those are the relevant parties. So remember, private actors, private interest holders, and federal interest holders. And then you are going to make sure you file it in the circuit court, no matter what was paid for that tax deed. And you are not going to name as a defendant to a quiet title suit a county or municipal lien holder. You're just not. So what are some common challenges once you have filed suit? Well, and this is based on my experience, kind of like the main challenges to your quiet title suit. Payments. So the challenge, obviously, that, no, I've made a payment, and that is a statutory defense to the tax deed. And I made a payment prior to that tax deed being issued. They did it in error. 2, assessments. Like I said, not all property is taxable, and not all property is taxable the way that it was assessed. And I'll explain these further in a second. Constitutional challenges, due process. Sure, the clerk did everything that was stated in 197522 of the Florida statutes, but it still didn't meet the constitutional burden to notify me. That is the most common challenge. And then you have the challenge of legal descriptions, issues that come up with legal descriptions. And that can be from the fact that, oh, hey, this legal description, it doesn't close. Or, oh, hey, this legal description, it overlaps on a neighboring parcel of land. Or, hey, this legal description doesn't cover the fact that there's a mobile home on the property, and I want to be able to get a title for that mobile home that's on the land that I just acquired. How do I do that? So these are common challenges to marketability, and I'm going to cover them one by one. So number 1, payments. Okay, payments. The statute which provides the ability for you to file an action to quiet title. I think it's 65.083. I think it's 65. So that statute is the one that states that a defense, the only defense to a tax deed is payment. And what does that mean? It means payment of taxes that were owed prior to the issuance of the tax deed. But it doesn't say payments of all outstanding taxes. It just says payments. And so you can have issues come up with that. What if somebody went up there and paid the taxes, the delinquency for one of the years? Well, now the numbers that have been used for the minimum bid to start the tax deed sale, now those are all wrong. That might be sufficient to undo your tax deed. So that is a payment challenge. Or, hey, I went the day before the tax deed sale and I paid the clerk and I have this receipt, and for whatever reason it was missed through processing and they held the sale in error. So those are some of the payment challenges that you can see come up. Normally, though, with payment things, if the person that had the tax delinquency or their mortgage lender, if they're interested in paying that tax delinquency, if they paid, they're going to raise that issue up very, very quickly with the clerk of court. It's not even going to get to the point where you file suit. Rarely. And the tax deed clerk is going to contact your client, the buyer, the investor, and they're going to tell them, hey, we are so sorry, but they made this mistake, or we made this mistake. We held the sale in error. They literally did pay us, and we're going to give your money back and undo that tax deed. So generally, very quickly, your client will know very quickly when a tax deed sale is getting undone because of payment. The issue that can come up with payment that isn't so clear until later is when the property owner, and this is something that you should be aware of. So let's say property owner has a big piece of land. So this isn't something that is relevant per se to like a residential property you're bidding on, but let's say a commercial piece of land. And they realize, oh my God, I cannot afford to pay taxes for this giant piece of land. I just can't. I'm going to subparcel my land. I'm going to make it smaller, break it down into pieces so I can sell this and sell that and keep this little piece, and I can afford this little piece. And so they go and they create the survey and they go to the property appraiser's office and they subparcel out into smaller pieces. And the property appraiser now creates an assessment for this one and this one and this one and this one. But if they have a delinquency in place, a tax delinquency in place, well, that history of the assessment of the delinquency, what's that going to be attaching to? The big piece here, this piece here, that piece there. And so if it goes to sale, let's say they're selling this big chunk here, if it goes to sale, that legal description might be tied to the giant parcel and not taking into account that there's this piece and this piece and this piece and this piece. And if that happens, those prior owners are going to create a legal nightmare for your client because they're going to say, well, I paid. That is a valid defense. What did they pay for? Was it sufficient to make the tax deed invalid? Was that subparcelization even supposed to happen if they didn't pay off the entire tax delinquency? These are all things that might be possible as a true issue when it comes to payments. So I want you to be aware of those possibilities. If your client is an investor in commercial pieces of land or in big, giant, vacant pieces of land, no matter how they're assessed, that subparcelization is an issue. And so when your client comes to you with those big parcels, you should look at the neighboring parcels and see if there's a common history, because that might give you a red flag kind of a thing about issues that might come up with payment. Technically, though, under the Florida statutes, the tax collector and property appraiser's office are not supposed to permit subparcelization, breakdown of parcels, without payment of tax delinquencies. They are not supposed to permit it, but it happens. And that's why we're here. Let's move on to assessments. So assessments, what are some of the assessment challenges that may come up? For you, you might be thinking, okay, well, an assessment issue that might come up is that they had improperly assessed it as non-homestead property. But the prior owners really did live there. It really was their homestead. And so they might challenge that it was improperly assessed and that therefore the tax liability thereon was improper, and therefore that, this tax deed was issued pursuant to an improper tax assessment and should be undone. I've seen those challenges. That is not as common as the tax assessment issues that come up when you have those special exceptions to taxation. So let's say that a church owns 3 lots. They're next to each other. You've got Lot A. Lot A is the church, where the church is at. You've got your thing. Clearly, under the exceptions in the Florida statutes, non-taxable land shouldn't get assessed, etc. Then you've got the adjacent parcel, and the adjacent parcel is, say, it's used as the parking lot of the church. And then you've got the next parcel, parcel C, and that is a little community center that the church used, or maybe they use it as a halfway house or something like that. But let's say the tax collector comes along, property appraiser comes along, and they look at parcel C and they're like, well, this isn't the church. We're not sure what it's being used for, so we're just going to assess it at the standard rate of, a little tiny 3-2, looks like a house. We're going to assess it that way. And so the church doesn't realize this. It's, they've got 3 different assessments, 3 different parcel ID numbers, one for the main church, one for the parking lot. Let's say the parking lot somehow gets exempt along with the church building. And they kind of ignore the tax bills that are coming here, or they've sent, letters to the state, etc. And they're going, hey, we're not supposed to pay taxes on this, but they never really pay attention to it, and the tax delinquency accrues and accrues and accrues. So now you've got an assessment issue, an assessment challenge. Taxes become delinquent, tax certificate holders want to pull it, and now the tax deed gets issued. And the tax deed is issued, and your client knows nothing about these challenges that are going back and forth between the church regarding that third piece of, is it used by the church, is it not used by the church? We're not sure how it's used, that kind of thing. And everybody got proper notice, so it's not a constitutional challenge. Everybody, all lien holders that were interested were noticed. Everything else was done right, except for the assessment portion. And if it is improperly assessed, that can make for a real challenge to the tax deed. Because if the tax liability on that piece of land was supposed to be 0, then absolutely there should be no tax deed issued thereon. So you might be faced with having to make the following argument for your client, and it's not the most fun argument to make. You're going to have to look through all of the statutes and the exemptions and see what steps did this prior owner, who you have no idea how they ran their business, what they did, etc. What steps did they take to make this an exempt property? It's a lot of discovery. It's a lot of fact-based determinations. Did they run it as a community outpost center? When did they run it as a community outpost center related to the church? Did they keep doing it every year since the creation of the church? Did they stop doing this? Did they abandon those projects after a number of years? Are the delinquencies related to when that use was abandoned? All of these are very fact-specific, intensive things that you have to think about when it comes to those assessment challenges for your client. And so just Be aware that the type of property should really trigger additional searches for you before you take on the case, before you draft the pleadings, so that you've got the best chance of success for your client. All right, so there's legal description challenges and then there's constitutional challenges. I'm going to address the legal description challenges first, and that is because the constitutional challenges is a lot more intensive and a lot more comprehensive, and so I want to get to that at the end. So legal description challenges I've mentioned briefly already. A legal description challenge involves there being an error in the legal description, or let's say the shorthand used for the legal description makes for an ambiguous legal description. So let's say Hamner's lot, or Hamner's subdivision. Well, there might be a Hamner subdivision, 3, 4, 5, or a Hamner's Candy subdivision versus a Hamner subdivision, and there's just enough similarity between two viable legal descriptions that there's now an ambiguous description that you're dealing with. So your job is to make sure that that tax deed, the way that it states the legal description when you're doing that analysis from your client at the beginning, it, one, closes if it meets and bounds. So you're a real estate attorney, you're working on quieting clouds to title, you need to know how to draw out legal descriptions. And you cannot just rely on surveys and surveyors. I mean, they're absolutely great professionals, etc., but sometimes it's just not done accurately, or they've made an assumption that wasn't really there, or they're using a legal description that's not the tax deed legal description. Your client is getting the tax deed legal description, and so you need to know what your client is getting or has received via the tax deed